Hello, my name is Jon Stefanik, and I'm a volunteer attorney at Colorado Legal Services, where I limit my representation to wills, powers of attorney, medical and financial, and uh, advanced medical directives, plus the administrative portion of probate. Um, Colorado Legal Services provides assistance to low income and senior residents of Colorado. The Colorado Springs office focuses mostly on El Paso and Teller County, although others are included. The managing attorney of Colorado's Legal Services, Sarah Lipka, has asked me to do a short presentation on estate planning. You should be able to see a basic estate planning outline as part of this presentation on the screen. It would be important for you to read the first paragraph. I will cover basic general concepts of estate planning. The presentation is not a substitute for individual contact with an estate planner, nor is it meant to be personal legal advice. It's my strong recommendation to each of you to have an estate plan. The goals of basic estate planning include a continuity of decision making. If incapacity becomes part of your life or the life of somebody that you're close to, it's very helpful to have someone set up to make financial and medical decisions. Minimize taxes and confusion. I've seen quite a bit of confusion at the end of life if there is not an estate plan. Address intestate statutory limitations. This goes to the next bullet point below, but if you do nothing, Colorado has a plan for you. I'm going to tell you it's not a bad plan, but it may not be your plan. So the limitations in the intestate statute are something that you may want to address. Well, the options that you have in estate planning are, number one is do nothing. And I've already said if you do nothing, Colorado has a plan for you. There are intestate meaning you die without a will. There are intestacy statutes in all the states and in Colorado. But if you decide that what Colorado has planned for you is not what you have planned, you can plan your estate. Basic estate planning comes in about 3 stages as far as I'm concerned. First of all is an awareness. That's where you are right now. You're watching this video and you've made up your mind that it's time to do something, whether it be a personal experience with a loved one or part of the national conversation in which over 200,000 of our fellow citizens have passed on due to the pandemic. You want to do something. Well, that takes you to the next step of estate planning, and that is action. All the awareness in the world is not going to help you unless you go to the next step, action. And the action I'm going to recommend is contact an attorney, estate planner, and set up some basic documents. We're about to get to those, but if you have those in place, you're pretty much there, except for follow-up. Your estate plan is not done until the day that you pass on. Things will change over the next 10, 15, 20 years, and your estate plan should coincide with the new priorities that you have in your life. So it's the case I've seen several estates, several wills come through the system that were made 30, 40 years ago, and nobody knows the names of the people named to, or nobody knows the people named to act on their behalf, and the estate plan is usually met with raised eyebrows. Now, when you go to see your estate planner, he or she will probably come up with the following. The basic documents are life situation and financial condition driven. First of all, I'm going to recommend a will. With or without a trust, sometime, depending on the size of your estate, there may be tax-saving portions to the will. The will takes care of things, the house, the bank account, maybe, the cars and other things, just basic things. Now, a durable power of attorney I recommend both a financial and a medical power of attorney. Financial power of attorney says when you cannot make financial decisions, here is the person that makes decisions for you. Um, the same thing with medical. If it comes to the point where you are temporarily incapacitated, cannot make decisions, let's have somebody out there that can make medical decisions for you. Next on the list is a medical surgical declaration, and you may have heard of it described as a living will. I think that's a horrible term because I've already described above a will, which disposes of things. A living will has to do with the situations at the end of your life. Typically, it comes into play within 6 months of your passing. It's important to have someone that knows a little bit about this document to talk to. Trusts, to me, are fact-specific. A fair number of attorneys in town, up and down the Front Range and throughout the United States, are going to recommend that your estate plan be based upon a revocable life trust. To me, again, that's fact-specific. It will depend on your discussions with your attorney and your personal situation. Irrevocable trusts typically come into play where there is an incapacity and a substantial estate. A person has an estate, certain amounts of property, but they are not capable of managing them. A good answer in that situation is an irrevocable trust. Testamentary trust is one set up within a will. Typically, it's for minor children until they reach an age where you determine that they can handle financial matters. The taxes at one point many years ago were a major concern. However, the federal tax exemption amount is $11.8 million. Now that's been adjusted, so it might be a little bit more. What that means is that if your estate does not exceed $11.8 million, there is no federal tax due upon your death. Same thing with Colorado. Colorado does not have an estate tax. There are some idiosyncrasies in larger estates, and I'll let you talk to your estate planning advisor on that. Now, it's a common misconception that you can only give $15,000 this year without a taxable event. I'm going to say that you can give any amount that you'd like to anyone. If it exceeds $15,000, talk to your accountant and have him or her produce Form 709 gift tax. The estate exemption amount is a combined gift and estate exemption. So upon your death, your gifts and your estate would be added together. As long as it doesn't exceed 11.8 million or whatever it happens to be that particular year, there is no federal tax due. Planned charitable giving can be tax advantageous. It can also be a handy tool in the event that you don't have a person that you would like to give your estate to. I've seen gifts to the Humane Society, religious organizations, and so on. Now, the next bullet point there, beneficiary designations, possibly should have been way up in the top, but if you have joint tenancy, a 401k with an IRA, or a 401k with a beneficiary, an IRA with a beneficiary, life insurance with a beneficiary, all those things pass by the terms of the particular contract. The will does not touch them. The problem here is keeping those beneficiaries up to date. You may have a 401k that you set up 20 years ago or 15 years ago, and the beneficiary is no longer the right person. This is something you can do to plan your estate and have the right person receive the benefits. Now, joint tenancy deeds are kind of an interesting approach. In Colorado, if the deed is in joint tenancy, and the default, by the way, is common tenancy, more on that if you need it, but in the event of a joint tenancy in real property, when the one joint tenant deceases, it is as if that person never existed. by the operation of law, at the moment of death, the surviving joint tenant becomes the owner. Joint accounts, bank accounts, same thing. It's important for you to maintain the right beneficiary and the right person as a joint owner. Another lecture, the next bullet point, is probate. We at Legal Services have presented this lecture in coordination with the Pikes Peak Library District. Another volunteer attorney at Legal Services, Michelle Glover, and I both do this. This is a condensed version, but you'll notice down here probate. And there's a hyperlink to all the forms, maybe not all, but at least most of the forms you would need to do a basic probate. We used to be at the courthouse, and we're hoping that at some point in the future, the courthouse will open on Thursday mornings for us to help folks with probate. That's about it. That's my 10 minutes. I wish you good luck. I wish you good health and good day.